Minister.
Thank you, Deputy Speaker. I rise to speak on the Royal Commission's legislation amendment Protections for Providing Information Bill 2026. This legislation proposes significant changes to the Royal Commissions Act. It aims to ensure that the Royal Commission into Anti-Semitism and Social Cohesion and future Royal Commissions can access intelligence and operationally sensitive information. From the outset, the Coalition believes that it is critical that the Royal Commission into Anti-Semitism and Social Cohesion is given every opportunity to succeed. The Bondi massacre on the 14th of December last year was the worst terrorist attack on Australian soil, an attack which directly targeted Jewish Australians celebrating Hanukkah. This attack was devastating to all Australians, but particularly to the Jewish community. The terrorist attack didn't happen in isolation. Since October 7, 2023, Australia has witnessed a disturbing and sustained rise in anti-Semitism. Jewish Australians have reported intimidation, harassment, vandalism, threats and social exclusion. Synagogues have been attacked and have required heightened security. Jewish students have described feeling unsafe on university campuses. Families have removed religious symbols in public out of fear. For many in Australia's Jewish community, the past 2 years have not simply been uncomfortable, they've been frightening. During that period, community leaders repeatedly warned that anti-Semitism was escalating. They called for decisive national action. The Prime Minister and his government ignored these warnings every step of the way. After the horrific massacre at Bondi, the Jewish community called for a Royal Commission. Victims' families wanted a Royal Commission. Yet when that call was first made, shamefully, Prime Minister Albanese opposed it. Instead of committing immediately to a Royal Commission, the Prime Minister proposed a narrow departmental review. He questioned whether a Royal Commission was necessary. He raised concerns about timeframes. He suggested it might provide a platform for extremist views. He suggested that so-called actual experts opposed it. To many Jewish Australians, that hesitation was an insult. It hurt deeply. Because a Royal Commission is not just another inquiry. It compels evidence. It overrides secrecy barriers and it signals that this is an issue of national significance. Let me pause there, Deputy Speaker, to make a couple of observations about the Royal Commission in a more personal capacity. The Royal Commission has been given a timetable which has been set by the federal government. As I said, it is a government that didn't want to have the Royal Commission in the first place, and it didn't want to ensure that the Commissioner has adequate time to do their job. Let me say something first about the inquiry into the security arrangements at Bondi, because the Commission held its first hearings last week. It's now March, and the government has given them a timetable to report on the security elements by the end of April. This is not a fair timeframe. The Commission has only been recently stood up. It will be nearly impossible for it to look at these matters with any thoroughness. The security matters before the Royal Commission deserve to be investigated thoroughly. And if the Commission needs to take more time to do it, it should be encouraged to take more time and take the time to do it right. 15 people are dead, murdered in cold blood on our streets. So my message to the Government and to the Royal Commission is do not rush this process. The second matter relates to those things that the Commission has been charged to investigate with respect to institutional and institutionalised anti-Semitism. The Royal Commission has made something of the need to report by the first anniversary of the Bondi massacre on the 14th of December. There were media reports last week suggesting that in private meetings between the Royal Commissioner and the families of the victims and the survivors of the Bondi massacre, that those survivors and families have told the Royal Commissioner to take more time if she needs to. As a Jewish Australian, I want to echo those calls to the Royal Commissioner. Take the time to get this right. There's nothing sacrosanct about the government's timetable. It's been set by the Albanese government, a government that did not want to hold a Royal Commission and had to be dragged kicking and screaming to call it. Can I say, as a Jewish Australian, there will be only one opportunity to investigate the depth and depravity of anti-Semitism in our country. We will never get this opportunity again. It is really important to take this opportunity to get under the hood of the institutions in our society, especially the universities and the arts bodies and school organisations. Anti-Semitism in educational and arts organisations are mentioned in the recitals to the Royal Commission, and the Commission will have failed if it does not look at those matters adequately. So if the Commission needs more time than the Albanese government has granted it, then it should be given additional time and it should take advantage of actually asking for extra time. As somebody who for the last 2.5 years has been calling for a judicial inquiry into anti-Semitism, this is absolutely vital. The Commission has a very good look at both. It is vital that the Commission has a very good look at both those sectors, the arts and education, because they are the areas where anti-Semitism has become, to quote the words of the Special Envoy, ingrained and normalised. I particularly want to say something about the university sector. The Commission will have failed in its job if it doesn't call the Vice-Chancellors and put them on the stand. The fact that a group of university chancellors could issue a statement on anti-Semitism that didn't even mention the word Jew or anti-Semitism is a disgraceful abrogation of their leadership. Absolutely disgraceful. The Commission must put Vice-Chancellors and former Vice-Chancellors on the stand, particularly in those institutions, especially in the Group of 8, where anti-Semitism has been rife. They must put the Chancellors on the stand as well. It must put Student Representative Council Presidents on the stand. It's their job to represent the views of all students and not make some students feel, or not make a select group of students feel ostracised. It must put the NTEU leadership on the stand. There have been many Jewish academics who have resigned their membership of the NTEU because it simply failed to stand up for Jewish academics during this time. And it must root out the anti-Semitism among the administrators of universities and among those bodies that purport to represent the universities. It must go deeper and examine what's taught about Jews in the classroom. It's disturbed me, Deputy Speaker, ever since I became the Shadow Minister for Education, that when I've talked to Vice-Chancellors, many simply believe that encampments are gone, they stood up complaints procedures, that's enough. And in some institutions, they believe that because they don't know that they've got a population of any Jewish staff or students, they don't need to worry about this issue. The truth is, this issue is broader than whether you've got Jewish students or staff, and it's broader than the Jewish community. It's about what's actually being taught in the classrooms about Jews, because what's being taught in the classrooms about Jews determines what the future of our society looks like. If we don't get this right, then we are setting our society up for on a course for a future based on conspiracy, not on fact, on othering, not personal responsibility, on social discord, not social harmony. What happens today on campus sets the tone for the Australia of tomorrow. That's why addressing anti-Semitism on campus is so vital, and that's why the Royal Commission must look at these issues. That's why their task is so important. That's why the Commission must be given the time that it needs to do this job thoroughly. And if the Commission fails in this opportunity to properly look at these matters, it will be failing the Jewish community and all Australians. The Jewish community has been calling for this government to take action for 2.5 years, and it will disrespect the memory of those 15 people who were murdered on Bondi Beach if it doesn't look at these issues properly. With that context in place, let me turn back to this bill. The Royal Commission's legislation amendment, Protections for Providing Information Bill 2026. This bill amends 3 key areas. The Royal Commissions Act 1902, three key laws. The Royal Commissions Act 1902, the Royal Commission's Regulations 2019 and the Criminal Code Act 1995. Its purpose is to ensure that the Royal Commission can access intelligence and operationally sensitive information, even where Commonwealth secrecy provisions would otherwise prevent disclosure. On its face, this is a practical reform. The bill inserts a new Part 4A into the Royal Commissions Act. It makes clear that secrecy provisions cannot be relied upon as a reasonable excuse to refuse compliance with the Royal Commission's requirements. In other words, intelligence agencies and law enforcement bodies cannot withhold relevant material solely because another law contains a secrecy clause. The bill also creates formal intelligence information arrangements and operationally sensitive information arrangements, which are structured agreements between the Commission and the relevant agency heads governing how sensitive material is obtained, stored, accessed, used, disclosed and returned. It provides legal protections for individuals who provide such information in accordance with those arrangements. It ensures they are shielded from criminal or civil liability under secrecy provisions. It also amends the Criminal Code to create a defence for individuals who deal with classified information for the primary purpose of communicating it to a Royal Commission. On their face, these changes strengthen the Royal Commission's hand. I want to turn to why this bill requires scrutiny. These are serious legal changes that the bill proposed. As the Royal Commissioner Virginia Bell has noted, her inquiry is the first Royal Commission in nearly 50 years to investigate aspects of the work of the Australian intelligence community. We have a duty to ensure that she has all the powers required to conduct her investigations properly. It's precisely because of the gravity of Commissioner Bell's Royal Commission that the bill requires careful parliamentary scrutiny. It's precisely because of the seriousness of the changes proposed that this warrants closer examination. These changes should be the subject of an inquiry from the Parliamentary Joint Committee on Intelligence and Security. That's common sense, it's good governance, it's in Australia's interests, and it's the Coalition's position. We need to hear from security experts, legal experts, our security agencies and law enforcement agencies, the Royal Commission itself and other stakeholders about how these laws will work. Because this legislation overrides secrecy provisions across Commonwealth law. It's not a minor adjustment. It reshapes the interaction between national security frameworks and public inquiries. Parliament must examine whether the scope of the override is appropriate. It must ensure the definitions of intelligence information and operationally sensitive information are precise and appropriate. It must ensure the arrangements governing handling of classified information are sufficiently robust. We must ask, are the safeguards adequate? Are the oversight mechanisms strong enough? Is transparency balanced appropriately with the security? The bill requires the Secretary to publish intelligence information arrangements as notifiable instruments. It's appropriate that the Parliament scrutinise what level of detail is made public and how variation of those arrangements will be monitored. We must also examine the evidentiary protections. The bill provides that information given in accordance with the arrangements is not admissible in evidence against the person in secrecy-related proceedings. That is an important protection, but it must be carefully calibrated so it doesn't unintentionally shield misconduct unrelated to lawful cooperation with the Commission. Similarly, the Criminal Code Amendment creates a new defence to certain secrecy offences where information is dealt with for the purpose of communicating it to a Royal Commission. Parliament must ensure that this defence is fit for purpose. If there are failings of intelligence practice or national security policy relevant to this Royal Commission, we need informed insiders to come forward. It is appropriate that the Parliament satisfy itself that the bill allows intelligence officials to safely, securely and lawfully disclose information to the Royal Commission on a voluntary basis, and that any underlying arrangements are properly designed and fit for purpose. Let me be clear. We do not oppose the bill's objective. On the contrary, we want to ensure that this gets it right. The Coalition wants this Royal Commission to be effective. We need it to be effective. It is recognition that legislation touching intelligence, national security and criminal liability demands rigorous examination, because the integrity of both national security frameworks and Royal Commissions depends on clarity and balance. As I said, the Jewish community deserves a Royal Commission that is powerful, effective and legally sound. They deserve a framework that cannot later be challenged as rushed or poorly constructed. They deserve a bill where all parties have confidence in that drafting and where there are no unintended consequences. Parliamentary scrutiny is responsible. It helps ensure that legislative architecture supporting the Commission is sound. The Royal Commission must have access to the information it needs, but in granting that access, we must preserve the integrity of secrecy law, the rights of individuals and the balance between transparency and security. That balance is Parliament's responsibility. As I said, on its face, this bill strengthens the Commission. It removes barriers to evidence and it protects those who cooperate. But because it overrides secrecy provision and amends the Criminal Code, it must be examined thoroughly, it must be debated openly and it must be refined where necessary. A PJCIS inquiry will not delay the Commission. I want to take a moment to say this. The Commission has operated effectively for 7 weeks so far, and the Attorney-General's Department has confirmed that it will be able to continue its work uninhibited while the Parliament scrutinises this bill. A PJCIS inquiry does not delay the Commission. Indeed, it serves a more important purpose. It shores up confidence that we have the arrangements right, that the Commission can receive the evidence it ought to hear. That does not occur, though, if the Parliament passes permanent changes to the national security legislation improperly or in a rush. So let us use the scrutiny provisions of this Parliament to support and strengthen the Commission. I thank the House.